Hi, everyone. Thank you for joining. It's Friday, December 19th, 2025. We're going to let everybody join in a little bit. I know we have a few people joining still, so I'll give a few minutes for everybody else to join while I go in and give my introduction. So while we do that, give it like I said, another little minute or so. Wait for everybody to hop in. So my name's Amanda. I am the HOA's program assistant here with the Division of Real Estate. As I said, it's Friday, December 19th, 2025. You've joined an HOA forum of an association meeting organized by the Colorado Division of Real Estate's HOA Information and Resource Center. As I said, my name is Amanda Lopez, and again, my role here is the program assistant here with the Division of Real Estate. And with me today, I have Nick Altman. He is the HOA's HOA Information Officer here with the Division of Real Estate as well. So before we begin, I'd like to go over a few housekeeping items and reminders. So the webinar is being recorded, and the recording will be uploaded to the HOA Center's website as well as the division's YouTube, page within a few days from this forum. And then also the Q&A feature is enabled for this presentation. So if you look at the bottom of your Zoom interface panel, you should see a Q&A icon where you have the option of asking a question. So if you prefer to remain anonymous while doing so, you have the option of selecting the Ask Anonymously box. We appreciate everyone's engagement, of course, and great questions. So to help us be as efficient as possible in answering your questions during today's webinar, please take a moment to check the current list of submitted questions in the Q&A to see if another attendee has not already asked your question earlier to avoid any duplicate questions. We're making the effort to ensure, of course, that we can continue producing these live presentations in the way that we have been. So again, please help us by carefully considering whether your question has been asked and answered in the Q&A. And just a friendly reminder, please ensure, again, the questions are related to the topic of today's forum, which is association meeting. All right, and just as a quick disclaimer, the information provided during today's presentation is for educational purposes only and is not meant to provide, nor should it be construed as legal advice. Any legal questions should be directed to a qualified licensed attorney in Colorado. So with that, let's go ahead and hop into it. So first I'm going to go ahead and explain what we do here in the Division of in the HOA Information and Resource Center. So what we do and what we do not do. So first, I'll go over what we do here. So the HOA Information and Resource Center provides information to homeowners regarding their basic rights and responsibilities under CCIOA, which is the Colorado Common Interest Ownership Act. We gather information, we analyze and report through complaints and HOA registrations. So sorry, I kind of said that kind of wonky there. So we gather, analyze, and report information through complaints and HOA registrations. We create resource materials. We provide education and forums, provide a website with information for the public. We register HOAs pursuant to 38-33.3-401 of the Colorado Revised Statute. And we provide an annual report to the legislator. And last, and then we'll go into, what we do not do. So what the HOA office does not do, we do not act as a regulatory program. We do not mediate or arbitrate on behalf of homeowners board members, or community association managers. We cannot provide legal advice. We do not investigate, nor do we intervene in disputes that arise between homeowners and homeowner associations. We do not act as an advocate. We do not assess fines or penalties, and we do not enforce an HOA's failure to register. So in our efforts to carry out the mission of the office, the HOA Center strives to remain balanced, independent, and unbiased when responding to inquiries and educating the public. So with that, I'm going to go ahead and pass the baton over to Nick. Nick, go ahead and take it away.
All right. Hi. Thank you, Amanda, for that introduction. Hello, everybody. Thanks for joining us today on our December HOA forum on HOA meetings, a very important topic and one where there tends to be a lot of confusion about how meetings should be ran and what are the types of HOA meetings and whether notices should be provided, whether homeowners are entitled to participate, and so on and so forth. So again, thank you all for joining. I hope everybody still has their power on today with all the crazy wind. And yeah, let's just get into it. So our talking points today, I'll do a quick overview of the Colorado Common Interest Ownership Act, what it is, why it's important. I'll talk about what is a homeowners meeting and the various types of HOA meetings. How frequently should they be held, and what are the notice requirements for the various types of meetings that we see in common interest communities? Are there any tips, or what should go in the meeting minutes, and how should the agendas be prepared? What does state law have to say about all this? I'll include a couple of quorum scenarios just to kind of help us wrap our brains around quorum and what quorum requirements are. Then I'll do a couple of best practices and pro tips, and I'll do my best to answer questions as they appear in the Q&A. With that, let's go ahead and get started. So what is CIOA? CIOA stands for the Colorado Common Interest Ownership Act, commonly abbreviated CIOA. It became effective on July 1st, 1992, and it is the Colorado law that governs the formation, operation, and management of common interest communities, or colloquially referred to as HOAs. You can find a copy of the CIOA Act at the statutory sections 3833.3-101 at SEEK, which is Latin for all that follows. The CIOA has, if you've been paying attention and following the legislation in Colorado, there's been a lot of amendments and changes to this act from the Colorado Capitol, and to my knowledge, there's nothing to suggest that this next legislative session will not also be a busy one with HOAs. This Colorado law, CIOA, as well as all the other statutes, are publicly available to review. I'll kind of throw another slide up here with instructions on how you can pull up the statutes yourself if you're interested in reading the actual text of CIOA. Of course, you can also email the HOA Information Resource Center, and we'd be happy to provide a copy of the law as well. So this slide, I wanted to show an example of how CIOA is amended and how it's important to understand and how to recognize when the statute itself is amended after a lawmaking session at the General Assembly. So if you pull up, this is an example from House Bill 22-1137, but if you pull up a PDF copy of the bill, you'll see an act at the top, and you can scroll down, usually, depending on the duration, the length of the bill. Some of them can be long, some of them might only be a couple pages, but keep an eye out for the section here that says Section 1 in Colorado Revised Statutes, amend so-and-so introductory portion and add the following sections as follows. So you'll want to, whenever a bill is passed and a new law is signed, you'll want to pay attention to what section of CIOA that bill is amending. And if you look at the bill, this is the section that'll explain that to you. So I won't read this entirely, but this is instructions on how to pull up a copy of the statute yourself through LexisNexis. First, you'll go to https://leg.colorado.gov, and you'll hover over laws at the top. That's the Colorado General Assembly main webpage. Scroll down to Colorado Revised Statutes, and then you'll prove that you're not a robot. And you'll start off, and then you'll see a list of all the titles, of all the Colorado titles, and you'll go to Title 38, Property, Real and Personal. Then you'll click a little plus icon to expand that submenu. The next menu you want to search for is Real Property, and then again, Interest in Land, and then finally, Article 33.3, Colorado Common Interest Ownership Act. All right, so what is a homeowners meeting? A homeowners meeting is a forum or assembly of sorts where the executive board and the unit owners meet to discuss business, veto the budget, hold elections, and help foster a sense of community. Of course, this isn't all that occurs in a homeowners meeting, but most generally, these are the things you'll see HOA meetings for. A meeting is not official and business cannot be conducted or votes cannot be taken until a quorum has been met. As far as board meetings, those board meetings must be properly noticed to the unit owners in accordance with any requirements in the governing documents of the HOA, and an agenda must be made reasonably available for examination by the owners, according to CCIOA. A homeowners meeting is not formally defined, just as a kind of as an aside there. But so what are the main types of homeowners? You have your annual owners meeting or the annual homeowners meeting, or sometimes you might hear them referred to as the annual members meeting. You have your board meetings, and then you also have your special meetings of the owners. And we'll talk about each one of these in turn here. So for the annual unit owners or homeowners meetings, the requirements are set forth in CCIOA section 308. And importantly, every HOA that is subject to CCIOA, and I believe even pre-CCIOA and other types of communities, must schedule and hold at least one annual members meeting per year. This is mandated by CCIOA and Colorado law. Colorado law further goes on to say that not less than 10 or more than 50 days in advance of any meeting of the unit owners, the secretary or other officer, whichever officer may be specified in the bylaws, shall cause notice to be hand delivered or sent prepaid by U.S. mail to each unit owner's mailing address. So this is just for the annual homeowners meetings. And as far as emailing the meeting notices, CCIOA does require that the annual meeting be sent by U.S. mail. So there's nothing wrong with emailing the annual homeowners notice, but it must be sent by U.S. mail first and foremost. The notice of the annual homeowners meeting shall be physically posted in a conspicuous place to the extent that such posting is feasible and practicable. So, you know, the community bulletin board, the notice board, maybe in the HOA's principal place of business would be a reasonable place. What would not be a reasonable place is the back of the dumpster or somewhere where there is not a lot of traffic or where people cannot see it. Again, can the board email the annual meeting notice? Absolutely, but it must, as I said, it must also ensure that it's being sent prepaid by U.S. mail to all the mailing addresses of all the unit owners. The annual homeowners meeting shall state the time and place of the meeting and the items on the agenda, including the general nature of any proposed amendment to the declaration or bylaws, and budget changes, and any proposal to remove an officer or member of the executive board. State law encourages associations to provide all notices and agendas in electronic form or by posting on a website, if such means are available, and if a unit owner so requests and furnishes a valid email address to the association, then the association shall provide notice of all regular and special meetings of unit owners by email. So for board meetings, executive board meetings, those are also found in 308 of CCIOA. So there's no state requirement as to how often an executive board needs to hold board meetings. However, most likely your governing documents will set forth their own requirements. And the board is entitled to call as many meetings as it needs in order to achieve its operational and management goals. All regular and special meetings of the association's executive board or any committee thereof shall be open to attendance by all members of the association or their representatives. So board meetings and special meetings cannot be closed off, or a board cannot prevent a group of owners from attending a regular or special meeting. Those must be open to all the unit owners. Agendas for meetings of the executive board shall be made reasonably available for examination by all members of the association or their representatives. Does CCIOA define reasonable? No, it does not, but probably 15 minutes before the board meeting starts, that's probably not a reasonable amount of notice to the owners. Likewise, it probably wouldn't be feasible to provide 3-month or 90-day notice of board meetings, since business changes so frequently and agendas change. So a reasonable amount of time to provide notice. Board meetings you will typically see follow Robert's Rules of Order, which is a parliamentary procedure. Though it's not required. It's not required that HOA boards run their meetings using Robert Rules of Order. Though you'll commonly see that from community to community. If you don't know who Robert is, I believe he was a U.S. captain in the 19th century who came up with the procedure to address large assemblies, large gatherings of people. And I guess he found out, along with his colleagues, that it was extremely difficult to run a formal meeting with that large number of people. So he came up with Robert's Rules of Order. So special meetings of the owners. So again, just like board meetings, there's no requirement as to how often an HOA, how owners or board meetings, excuse me, must hold a special meeting. Though as many can be called as is needed to achieve the goals of the community. So there are 3 ways. There are only 3 ways that a special meeting may be legally called. Number 1 will be by the HOA president. The HOA president has authority to call a special meeting. Number 2, by a majority of the executive board, or by 3, unit owners having 20% or any lower percentage specified in the bylaws of the votes of the association. So an equal number of unit owners who have at least 20% of the votes of the association can call a special meeting. The special meeting has the same notice requirements as the annual owners meetings. If a unit owner requests annual or special meeting, the notice must be delivered by email and provide assuming the owner provides the association with a valid email address, the association must accommodate that request. So if a group of owners legally call a special meeting and request that the association provide that notice by email, then the association must accommodate that request. For notice of special meetings, the association must provide notice as soon as possible, but at least 24 hours before the meeting begins. See CRS sections 3833.3-308 2BI, or Roman numeral 1. So why might a community call a special meeting? You'll commonly see them for a board recall, or to discuss potentially removing a board member. Maybe the community just wants to call a special meeting for a certain issue that has arisen or that needs extra attention. Also, a special meeting might be called to consider an extraordinary or unplanned emergency event or an expense that was unforeseeable. Owner requests for a special meeting must be in writing and signed by the owners who are requesting the special meeting, per the Colorado Nonprofit Act. So here's where we see again the Colorado Nonprofit Act relate to Colorado HOA law and how it impacts HOA operations. The Colorado Nonprofit Act permits an owner signing the demand to set the time and place of the special meeting and give notice to the community if the association fails to act within 30 days of receiving a valid demand. So this is a provision in the Colorado Nonprofit Act that permits the group of owners to set the time and place of the special meeting and give notice in accordance with the governing documents if the association itself or the board fails to act within 30 days of receiving a valid legal special meeting request. All right, just as a quick reminder, how to call a special meeting by the HOA president, a majority of the executive board, or unit owners having 20% of the votes of the association. All right, so there are other types of meetings, and obviously this one's very important. Virtual meetings are becoming commonplace pretty much everywhere you go. You know, Zoom, Microsoft Teams, maybe WebEx has virtual capabilities, meeting capabilities. And the reason why I didn't include these as the colored blocks is because they're not really mentioned too much in Kiowa, if at all. There's a few provisions, but not as much as Kiowa mentions the annual owners meeting and board meetings. So again, virtual meetings are authorized by the Colorado Nonprofit Corporation Act. One of the primary requirements is that board members must be able to hear each other in the virtual meeting. So if one board member cannot hear another board member, then that is not a valid virtual meeting. These virtual meetings must be open to owners or their designated representatives. Existing board meeting notice requirements, if the HOA has any, must be utilized and followed. If there are board meeting notice requirements, a link to the virtual meeting must be provided to the owners so they can join. So again, the association, the board cannot prevent owners from attending virtual meetings. And how do you join a virtual meeting? You need a link, right? Most of the time you need a link. So a link to that virtual meeting needs to be provided to any owners, especially to owners if they request it, but it might be best practice just to be open about it and publish that link somewhere in your HOA newsletter, HOA website, somewhere. Same quorum requirements apply for virtual meetings as it does for annual owners meetings. So you need quorum requirements to begin the virtual meeting. Board member votes needs to be clear and obvious so the owners are able to confirm how board members are voting. So if a board member turns their video off and mutes themselves during a vote, if a vote is happening, if a board member turns off their video and mutes themselves, there's no way to validate how they voted. So the votes must be, owners must be able to confirm, and as well as other board members, how the votes are occurring, yay or nay, or even if they're abstaining. So a question might be, is it permissible to restrict owner comments to, to a reasonable amount of time on each respective issue that's being discussed? Because according to Colorado law, prior to any action or vote occurring, the owners must be granted an opportunity to be heard. That's just a requirement by Colorado law. But boards cannot vote unless they offer the owners an opportunity to be heard. So this isn't to say exactly that, okay, if you're a board, we have to allow an owner to speak for 20 minutes and derail the meeting and it turns into like a kind of a complaint fest. It is permissible and it's encouraged and advised that boards, they're supposed to be adopting a conduct of meetings policy. All HOAs should have a conduct of meetings policy, but if not, they should absolutely get on that immediately to adopt a conduct of meetings policy and put in there some reasonable restrictions on the amount of time that owners can comment or speak in those owner forums that are part of the typical board meetings. So is a reasonable amount of time 12 seconds? Probably not. Again, also in order to conclude the meeting and to get business done, it's probably not reasonable to allow each owner 15 minutes to speak. So something about 3 to 5 minutes per owner. and make sure this is reduced to writing and mentioned in the policies of the association. And also before the meeting starts, just remind folks, hey, each person has 3 to 5 minutes, and that's that. So executive sessions, I'll get into these more in a little bit, but the board has the ability to enter into an executive session in virtual meetings as well as in-person meetings. So what about muting? I hear a lot about, the board muted me midway through my comments. It is permissible as long as it's done in accordance with that conduct of meeting policy, and it's somewhat even it's encouraged to mute unruly or disruptive owners if they're preventing the normal proceedings of the meeting. So again, owners should be entitled to be heard, but for a reasonable amount of time. So we do see, some other types of miscellaneous HOA meetings, and of course that includes the budget meeting and committee meetings and architectural review meetings. But again, just like the annual and board meetings, these all must still be open to the general members, and members must be allowed to participate in these meetings. Yeah, just similar to virtual meetings, committee members may enter into an executive session. CCIOA does grant that right as well to committee members during a committee meeting if they need to enter into an executive session. All right, I wanted to kind of see if we had any questions here real quick, just because it's just me today and I don't have my colleague David here. Let me see if I can. If there are any questions I might be able to answer that are sitting in the Q&A. And I was going to allocate maybe 1 or 2 minutes to this. All right. So unfortunately, I will not be able to provide a written response in the chat, but I'll see if I can answer any of these live. Okay, so Barbara asked, aside from the annual meeting, is it okay to require notifications of other meetings be via email or a group calendar such as Google Calendar, even if an owner refuses to supply email address? The annual owners meetings, there must be a physical US mail notice mailed out. Everything else is sort of just additional or extra, I guess you can call it. So if an owner requests that the annual notice is emailed, then the association has to comply with that request. Let's see. There are some questions about limited expense planned communities. Those are exempt from a lot of CCIOA, so I'm not going to get into that in this call. Feel free to email me though. Are there any? Irene asked, are there any laws about boards using a private forum for board members only to have discussions? And yes, that's going to be executive sessions, which I'll get into here in a minute. See if I can. And while I'm going through here, feel free to drop some questions in there too, because I know I tend to go kind of fast. And there's a lot of information, and the law is complex. So somebody asked if an annual members notice was only sent by email. However, a quorum was present by Zoom. Are the actions taken at the meeting valid? I can't really answer that question. It would depend on what the actions were, and there might be an argument that because not enough of the owners were invited or allowed to participate in the meeting, there may be an argument that those actions are not valid if there was no U.S. mailing notice mailed out. But I'm not quite sure I can answer that one. You might need to seek legal advice on your particular circumstance. All right, let me get back to the presentation here. Okay, so what is a quorum? quorum, and let's see, Amanda, if you can just give me a thumbs up if my audio is still coming through here clear. Amanda, do I still have you on the call?
Yeah, I thumbed up you.
Great, thank you, Amanda. Appreciate that. I just wanted to be sure I'm not talking on mute this whole time.
You're okay.
Okay, great. So, what is a quorum? A quorum is Oxford Dictionary defines quorum as the minimum number of members of an assembly that must be present at any of its meetings to make the proceedings of that meeting valid. So, what are quorum requirements for our HOA annual owners meetings? Okay, so the quorum requirements will first be found in your particular HOA governing documents, probably the bylaws. If you're looking at your bylaws and the bylaws are silent on quorum requirements, in other words, it does not contemplate the concept of quorums, which you'll probably be hard pressed to find too many HOAs in Colorado that do not have their governing documents establish this. But if they're silent, then a quorum is deemed present if persons entitled to cast 20%, or in the case of an association with over 1,000 unit owners, 10% of the votes which may be cast for election of the executive board are present in person or by proxy at the beginning of the meeting. So, annual owners requirements. First, check your bylaws. If silent, it's got to be 20%, 20% of the voting members. So what about quorum requirements for the executive board meetings? Iowa says that unless the bylaws specify a larger percentage, a quorum is deemed present throughout any meeting of the executive board if persons entitled to cast 50% of the votes on that board, so board members, are present at the beginning of the meeting or grant their proxy as provided for in the Nonprofit Act. So for a board member to be valid, there needs to be at least 50% of board members present at the beginning of the meeting. Some more information on proxies. So a proxy essentially is just it could be a piece of paper or a napkin. It permits a unit owner to vote without needing to be physically present at the meeting. So sometimes you might see a time of an HOA meeting at a time of day that not many owners can attend, maybe like 3:30 or 4 o'clock or even 5. So if an owner is unable to attend, they have the right to assign their proxy to another member so that other member can vote in their stead at the meeting. The Nonprofit Act provides that a member or unit owner may appoint a proxy by signing an appointment form. So the Nonprofit Act does not say that HOAs must require owners to use their in-house proxy form. There's nothing to suggest that owners must use, the HOA's proxy form. As long as the owner signs and dates a piece of paper, that is essentially consent. That is legal consent that the owner has granted their proxy form to another member. So Kiowa does require that the proxy be dated, or if it's not dated, it is considered void. So again, it has to be signed and dated. So there was recent legislation. I believe it was Senate Bill. Nope, not that bullet point. Senate Bill 22-059, I want to say, but it was in the 2022 legislative session where Kiowa was amended to require that a proxy may only be valid for a maximum of 11 months from the date of execution. So a owner cannot go around collecting 30, 40 proxies. I mean, they can. Those proxies cannot be. They expire 11 months after the collection of those proxies, and those proxies must be dated. So the same 40 proxies cannot be used for a meeting that's occurring in 2025 when the proxy forms are dated in 2022, for example. They expire. They become void after 11 months. The Colorado Nonprofit Act does authorize the board, I believe it's the secretary, to reject the proxy if the secretary or the board acting in good faith has a reason to doubt the validity of the signature on the proxy form or for the signatory's authority to sign for that member. So there is a responsibility on the board to review all the proxies and make sure, and society is going more and more virtual. So it's becoming more difficult to, it's not like you have a handy piece of paper with all the signatures on it. But the Nonprofit Act does authorize a board to reject a proxy form if the signature is in doubt. And you might see an issue come up with a signatory where there might be multiple owners on a deed, and there might be a provision in your governing documents that say only one owner who's on the deed may vote in a owners meeting or in a meeting. The Nonprofit Act does also provide this authority for the board to inspect or to review a signatory's authority to actually vote on behalf of the grantor of the proxy. Okay, so what is an executive session? Executive session is an important topic, and essentially it's a tool or a mechanism by which an HOA executive board can enter into to discuss confidential information or information that is private or that upon release could be damaging to any parties involved. So it's a very important tool. Boards should understand when they should go into executive session, as well as which topics of discussion they are restricted to discussing once they do enter an executive session. For these executive sessions, the owners must be prevented, or the board must separate its proceedings from the regular owners. Regular owners cannot see what's, the proceedings of the conversations that are happening in the executive session. It's protected. The information is protected and should not be disclosed. A couple important key items about executive sessions. So prior to the time the members of the executive board convene in executive session, the chair of the body shall announce the general matter of discussion. Before the board officially enters, the general topics of the general matters need to be announced. The board's going to speak with legal counsel, or it's going to discuss delinquencies or matters that are identified in CCIOA that we're permitted to talk about per CCIOA. Another important provision is that no rule or regulation of the board or any committee thereof shall be adopted during an executive session. So while the board does have authority and the right to enter into executive session, they cannot conduct regular business. So they cannot vote, or they cannot take an action or make an official decision on a matter while in executive session. A rule or regulation may only be validly adopted during a regular or special meeting or after the body goes back into regular session following an executive session. Okay, so again, I copied that bullet point. So the general matters of discussion are as follows: A through F. So there's 6 items that a board may discuss once they do enter in. So beginning with subsection A here, matters pertaining to employees of the association or the managing agent's contract, or matters involving the employment, promotion, discipline, or dismissal of an officer, agent, or employee of the association. So I guess commonly you'll see this utilized when the board wishes to discuss the current management contract. The current management contract. It doesn't really suggest or say that the board can discuss potential new contracts or new bids, but only matters pertaining to the managing agent's contract. So that's one reason that they can legally enter into an executive session. The second reason, or B, is for any matters that would involve consultation with legal counsel concerning disputes that are the subject of pending or imminent court proceedings, or matters that are privileged or confidential between attorney and client. And this is just your typical standard attorney-client privileged information. Any communications that the board wishes to have with its attorney may be discussed in executive session. And those communications must be protected under the attorney-client privilege doctrine. C, investigative proceedings concerning possible or actual criminal misconduct. D, matters subject to specific constitutional, statutory, or judicially imposed requirements protecting particular proceedings or matters from public disclosure. This one leads to a lot of confusion, and it is a little bit confusing. But just know that matters that are specific, I believe it's between communications between Congress and certain federal agencies. But if the board is not sure whether it needs to enter into for a matter that might fall under this provision, it should seek legal advice to ensure that it's proper and allowed for. E is any matter, the disclosure of which would constitute an unwarranted invasion of individual privacy. So, the board can enter into an executive session if it needs to discuss delinquency, for example. Those matters should not be discussed in an open meeting, like, neighbors who may be delinquent or behind on their dues. That should not be discussed in an open meeting. Those should be reserved for executive sessions. And then finally, review of or discussion relating to any written or oral communication from legal counsel, which relates to the earlier talking point, I think, for legal correspondence, legal communications. So these requirements can be found at Section 308 if you wish to pull them up yourself. All right, so another type of meeting that we commonly see is working session, or kind of informal session, I guess, or a working session. So this is not a meeting that's defined in Kiowa, but on the same hand, it's not prohibited by Kiowa either. But if a board does wish to use working sessions, then it must be done in accordance with any HOA governing documents, provisions, or restrictions. But what is a working session? Basically, it's just a gathering of not only the board, but also the unit owners, or any other interested HOA party, where issues and general community topics might be discussed. Key points, but not voted on. So pretty much anything can be discussed in a working session, as long as there's no votes taken or official actions concluded, then these types of meetings are permitted. But key points, sorry if my mouse cursor is going crazy, let me try and fix that. Key point, these meetings may not be used as official meetings where votes are taken or decisions are made. So because that these are not considered official meetings of the association, unit owners do not have a right to notice of a working session, or a right to participate, and minutes are not required to be taken either, because it's not considered an official meeting of the association. However, if an owner requests to be included or requests to join the working session, then the board should, and I may even argue must, allow the owner to attend and to participate in the same way they would a board meeting. So in this case, a board should be very careful when it is utilizing working sessions, and it may even consider just not holding these types of meetings, just to avoid any potential liability or pitfalls that might happen if the ownership suspects the board to not be acting proper. Okay, let me take a quick break here, check the Q&As. And Amanda, I know you're here. If you saw any questions that
There,
So I know we had a couple coming in here.
there are some very good questions coming in. However, I know I didn't want to jump the gun. I know you were touching on the subject here, so I wanted to wait for you to kind of go over some of these slides before I jumped in and answered. A lot of them you did answer in one of the slides as far as the meeting. Well, obviously all of them are meetings, right? But there is one as far as we have a few questions on quorum still. So let me just find one.
Yeah, I got one here. It's okay. Thanks, Amanda. This was submitted anonymously. Do board meetings need to be announced via USPS, or is an email notice acceptable? I think I already answered that, but USPS stands for United States Postal Service, which I believe is the same as US Mail. Let's see. Again, I'm not going to be able to get through all of these, but I will try my best to answer some of these. And if I didn't get around to answering your question on this call, please feel free to email Dora_DRE_HOA inquiries at state.co.us. All right, so here was a question submitted anonymously. At times, as board members, we meet every other week for several months to conduct business. Do these have to be called meetings? If we have to follow all the requirements for a board meeting, this is all too arduous. Yes, they do have to be called meetings. If the board is gathering and making decisions and voting, they have to be official board meetings that are ran in accordance with the bylaws. If I do understand that it could be a lot of paper pushing and even expenses with as far as the mailing notices out to owners. But if that's the case, the board might consider just reducing the number of board meetings that it's holding, just to say quarterly, or maybe certainly not every other week, just an option. Okay, so there's one question about whether minutes need to be taken for the executive session, and they should not be taken for topics that are addressed in executive session. For the regular meeting, yes, the executive session has to be attached, if you will, to an official meeting of the association. And in the meeting minutes, it has to say at what time the board entered into executive session, as well as the topics that the board discussed. So, and those just need to be vague, very high level. They cannot disclose any private information or any privileged attorney communication, but they do need to state the general topic that the board is discussing. And then, while this might be an obvious qualifier, the board also has to announce when it has officially exited the executive session. Okay, here's one. What can homeowners do if we aren't invited to board meetings? Well, for one, check to make sure that your contact information is current and up to date with your board. Make sure they have a valid mailing address, a valid email address. If they're not following the governing documents, the board, the owners can consider removing the board members. If they're in violation of the governing documents, that's not good. And the owners have the option of removing a board member. Of course, there's always litigation and alternative dispute resolution. And we'll try one more here. I believe I discussed proxies already. So there was a kind of like a question in practice. How does the board exercise these executive sessions? The board could go into a different room. They could just get up, leave the room, go into another room. If it's a virtual meeting, the platform that the board is using should research the platform ahead of time to make sure that a private room can be created, or that the rest of the ownership is prevented from that session. Most virtual platforms provide this capability. Zoom does, to my knowledge. Teams does, but just a way that the board enters into a separate private room. In practice, it really isn't super difficult just to ensure that the regular ownership is excluded from those proceedings. Okay. Getting back here. Okay, so as far as unit owner participation, for how can owners participate in meetings, CCIOA does set forth that at an appropriate time determined by the board, but before the board votes on an issue under discussion, unit owners or their designated representatives shall be permitted to speak regarding that issue. The board may place reasonable time restrictions on persons speaking during the meeting. If more than one person desires to address an issue and there are opposing views, the board shall provide for a reasonable number of persons to speak on each side of the issue. So again, it doesn't define what is reasonable, but I think we've discussed that already. And check your conduct of meetings policy to make sure that it is in accordance with CCIOA, with this section, and that the board is not inadvertently preventing owners from speaking. So I kind of wanted to just do a couple of quick quorum questions here for just to kind of help us understand quorum a little bit better. So I created some questions and posed some hypotheticals here, but this first one here touches on annual owner meeting quorum requirements. So an HOA has 50 unit owners who may cast a vote for election of the executive board. I know that's how CCIOA defines these types of owners who can vote. But essentially, so the HOA has 50 unit owners, 50 units with 50 owners who can vote. The HOA governing documents do not contain any quorum requirements, i.e. they are silent. The annual homeowners meeting is scheduled to start at 6:30 p.m. Mountain Time. So how many unit owners are needed to make quorum at this particular meeting? Does the time of the meeting matter as far as meeting quorum requirements? No, actually the answer is 10. So 20% is needed in this particular instance, which equals 10 unit owners need to be present at the beginning of the meeting in order for the meeting to officially begin. So number 2, this relates to executive board meeting quorum. So an HOA has 200 unit owners. The HOA bylaws state that 25% of unit owners must be in attendance at the beginning of the meeting at the annual owners meeting in order for a quorum to be met. Proxies may be used if the homeowner is unable to attend. And I apologize, this is another one relating to annual meetings, not board meetings. There are currently 46 members present, and one of the 46 members has 3 executed proxies, which have been given to the secretary. Is there a quorum at this particular meeting? So the answer is no. There is not 25% of unit owners, i.e. 50 members, 50 owners represented at this meeting, so there's no quorum. Even though proxies have been used, and there seem to be a lot of members at this assembly, 46, but because 25% has not been reached, which would be 50, there is no quorum at this meeting. Okay, here is my board meeting quorum question. So number 3, the executive board is about to meet for its quarterly board meeting. This is a particularly apathetic community with only 14 unit owners out of 80 in attendance. There are many important issues the board needs to discuss and vote on, including hiring a new community association manager and whether to continue a snow plowing contract. HOA member John is surprised to learn 2 of the most charismatic board members, Jesse and Bruce, are absent from the board meeting, even though the other 3 out of 5 board members are still present. Is there a quorum at this executive board meeting? And the answer is yes, because persons entitled to cast, remember, 50% of the votes on the board are present at the beginning of the meeting, 3 out of 5. So quorum has been attained. Okay, moving into meeting agendas. So there's no state requirement other than the meeting notice, other than that CCIOA says that the meeting notice shall state the items on the agenda, including the general nature of any proposed amendment to the declaration or bylaws. any budget changes, and any proposal to remove an officer or member of the executive board. Other than that, state does grant pretty wide latitude for what does or does not go on a meeting agenda. But keep in mind, though, if the board is considering amending the declaration or proposing any sort of amendment to the declaration or bylaws, then there must be an agenda that is made reasonably available to the owners. Same thing with any changes to the budget, any budget amendments, or any proposals to remove an officer or member of the executive board. Agendas for meetings of the executive board, not for the owners meeting, but for the executive board, shall be made reasonably available for examination by all members of the association, or their representatives. Again, it doesn't define reasonable here, but again, 20 minutes is probably not reasonable, and semi-annual 6 months is probably not reasonable either. The association is encouraged to provide all agendas in electronic form in addition to printed form, but CCIOA does not require agendas to be provided electronically. And this can be found at section 308. Okay, so moving into meeting minutes, the association shall keep as permanent records minutes of all meetings of the unit owners and all meetings of the executive board, and or a record of all actions taken by the unit owners or executive board without a meeting, and or a record of all actions taken by any committee of the executive board. So for both annual and board meetings, there must be minutes taken. Is there any rule or process or anything special about what needs to go in the minutes? Not really. But typically you'll see community managers prepare board packets, which includes like a membership list, for example, a list of the owners and their physical address and their voting, how many votes they're entitled to. You also see financial statements, committee reports, maybe the conduct of meetings policy, and any other business items that the board needs to review. The minutes should be more of a summary as opposed to a verbatim word by word, like trying to capture every single word that is said. It should just be a high level summary of, especially when any vote is taken or decision is made, something that if a individual at a future point in time were to pull up those minutes, that they would be able to determine or identify when a vote was taken or when any important business matters occurred. The only section of CCIOA which speaks to the contents of minutes is 3087, which states that minutes of all meetings at which an executive session was held shall indicate when the session was held and the general subject matter of what was discussed. And I forgot to include a point on here, but I do want to mention that minutes need, as far as approving minutes, meeting minutes, they must be approved at the next in-kind meeting. So for board meetings, if the HOA has quarterly board meetings, and let's just say, the board just conducted its March board meeting, the March minutes will be considered a draft until those minutes are approved at the June board meeting. So at the June board meeting, the board will probably, that should also be included in the board packet, to approve the last meeting minutes, to make sure that it's approving the last meeting minutes. For the annual meetings, that's once per year. So, and the annual meetings minutes gets approved by the owners, not the board members. So that might, that would require a full 12-month period to elapse until the minutes are formally approved. Okay, so just some helpful reminders here about what we've been talking about. The unit owners meeting quorum. Check your bylaws first. If they're silent, then 20% of unit owners is required. Agendas for the unit owners meetings, items included on the meeting notice. And then minutes, a permanent record must be kept. So for board meetings, the quorum requirements is 50% of the board members present. The agenda shall be made reasonably available ahead of time, and a permanent record must be kept for the minutes, just like for the annual meetings. Kind of wanted to get through some pro tips here because I know it's right about 2 o'clock, and I can't believe I've been talking for almost an hour. Okay, so don't forget to follow your governing documents. I can't stress enough how many times boards just kind of lackadaisically go through and try and hold a meeting, or they don't. They think what they're doing is right, but in reality, they never once picked up their bylaws to ensure that what they're doing is legally compliant. Make sure the quorum has been established before conducting any kind of business. If the board is trying, if it's making a good faith effort to hold board meetings, but it can just never obtain quorum, it just cannot proceed without meeting quorum. So try again, try holding another meeting and sending out more notice. And the quorum has to be made or the meeting is not valid. For board meetings and just meetings in general, prepare a well-organized agenda to avoid wasting time on unimportant issues that might arise. So stick to the agenda and hopefully business can be achieved. Allocate a set amount of time per issue or per matter, 5 minutes, 10 minutes, and stick to it. Again, there is the mute option. So if there is an unruly owner, and as long as this is mentioned ahead of time and in writing somewhere, the board should exercise its ability to mute disruptive owners in meetings. Of course, it's different for in-person meetings. There is no convenient mute option for in-person meetings. But again, can't stress enough a good conduct of meetings policy. Have concerned homeowners submit their questions before the meeting even begins to allow the board to do some research beforehand, so it's not caught red-handed, or the board doesn't know what it's talking about. Attempt to hold meetings in a neutral location, such as a recreation center or library conference room. I have seen some communities host their board meetings at a board member's house, which could be, it could be a bit intimidating to some owners who might not wish to go into an owner's house, or there could be some perceived conflicts of interest. So it's best just to hold these meetings in a neutral location. The community association management office is usually a pretty good place, or rec center or any other location that offers a neutral gathering space. Discuss the conduct of meetings policy before the meeting starts and highlight those important points. Bring copies to the meeting in case the board finds itself in a precarious situation. If the association doesn't have a community association manager, it might consider hiring one to help professionally run these meetings. All owners are entitled to meeting notices, even if some owners are not eligible to vote. So I do see this quite a bit too, where a board prevents certain owners from, or they just don't invite certain owners from attending the meetings, or they prevent the owners from attending the meetings if they are, say, delinquent on assessments, or perhaps they have violated a certain covenant or a rule of the community. Even if the owner is delinquent, they still must be invited to the meeting, and they still must be allowed to participate in the meeting. Boards ensure that the association member list is current and accurate, and that the board has accurate contact information for the owners. This has to include, it doesn't have to include too much, but just what is required by, I believe it's the Nonprofit Act, is the member's name, the address, and the number of votes each is entitled to cast. It does not say email addresses. It does not say telephone numbers. Do not include that information on the member list. Only include the name, the address, and the number of votes each owner is entitled to cast. Boards determine voter eligibility ahead of time. Some communities require voting members to be current on assessments. I know that kind of contradicts what I just said, but if there are any restrictions, which there may be, check the governing documents and ensure that they're not being prohibited from voting. but there may be some other restrictions, such as an owner might lose their right to enjoy certain amenities or common elements in the community until they're up to date on their assessments. But this should not be used to prevent an owner from voting. Okay, and so we're just a couple last items on how to navigate our website and where you can find useful resources. Where can I locate slides and recordings of HOA forums once they become available? So within a couple days, we will upload these slides to our website, and you can also review the YouTube video at your leisure by visiting our website here. You can see the URL in the top address bar. And if you scroll down the webpage and expand the accordion that says education and outreach opportunities, and then where that red arrow is pointing, recent HOA forums, presentations, and video. That'll take you to another page that has a list of all of our recent Zoom webinars where you can review at your own pace, as well as pull up, and I do believe you can download a PDF copy of the slides if you wish. Where can I locate the frequently asked questions FAQ on HOAs? That's just right next door, right across the way on the same web page. You'll see frequently asked questions and the link there, which will take you to a very, very in-depth and very detailed Q&A list, which the HOA Center has provided, which contains a lot of great information on some of the most frequently asked questions this office receives. Where can I locate the board member education resource page? Also another great link, another great page that goes into board member responsibilities and rights. And I do highly recommend taking a gander at that link. And I think that just about concludes this one. I know this is a very HOA law, and CCIOA is a very complex law, and there's a chance I didn't get to your question, or maybe I said something that might have been a bit confusing. If I did, I want to apologize ahead of time, but do feel free to email your questions in, and I will certainly get back to you at a later time. So last time here for Q&As. I'm going to give this 2 minutes and then conclude this. Another question on working sessions. Again, there's nothing to prevent a board from going into a working session as long as it's not voting or making any official decisions regarding community affairs. Can the board members have meetings on their own without homeowners? I think this sort of just tangentially relates to working sessions. And I think that is permissible, again, as long as no votes are taken. And that's I think if a board does do that, I think it should inform the owners that on occasion it'll enter into working sessions. The owners are invited. This is the time and place that the working session is going to occur. But there's no requirement that owners are notified. But the board should be as transparent as possible when it is using working sessions. What if the proxy is not assigned? Can the board fill in the blank, or is it used for quorum only? A board cannot fill in a blank if there's no owner who has signed and dated that proxy. Also, I've seen, I think more often than I would like to see, I've seen boards and managers try and say something like if the owner abstains, or if we do not receive a proxy, that vote is counted as a yes vote. That's absolutely not permitted. Cannot do that. I know there's always challenges with trying to obtain enough interest and participation in voting and just trying to get stuff done. But a board should not be counting a no vote or a blank vote as a yes vote. Is there a limit to the number of proxies assigned to one person, i.e. can one person be responsible for 50 proxies? I think yes. I think one person can, if they can generate enough interest and if enough people support their position, that person can collect as many proxies as they desire, as long as each proxy's got a valid signature and a valid date on it. I think the association cannot put a cap on the number of proxies that an owner can collect. Where can I get an example of a proxy for annual meeting? The internet is a pretty good resource for that. The HOA Center, unfortunately, we don't have any templates that could be used for proxies. But the internet's a great resource. You can also check with the Colorado Bar Association. They might have some useful templates to use, not only for proxies, but also for just other types of notices and correspondence that you might find helpful. Again, that's the Colorado Bar Association. Is it acceptable for the association's management company to collect and manage proxy forms? I would say the authority has to be granted in the management contract, and it cannot be done. It cannot be contradictory to anything that's already set forth in the governing documents or in CCIOA. And as far as secret ballots goes, I do know that a neutral third party has to count those secret ballots, and that can be the community association manager, as long as they don't have any vested interest in the outcome of that vote. If that vote doesn't affect their standing or might impact the contract in any way, then the community association manager should be that neutral third party to count the votes. But that's not really in the purview of this HOA forum. All right, so yeah, I really do appreciate all the participation here. We've had 55 questions come in. I think I'm going to call it though. I think I'm going to conclude this session. I appreciate everybody coming in today and spending their time with me, and also to Amanda for helping out with the introduction. If you click on the chat, you should see the HOA email address, the HOA Center's email address. Yeah, thank you. Feel free to share if you had any topics you would like the HOA Center to discuss in future HOA forums. Also, feel free to share your comments or thoughts on that. We always appreciate feedback. Amanda, unless you had any final closing remarks.
No, thank you everybody for joining. Yeah, thank you. And thank you, like Nick said, for the amazing, great questions. And Merry Christmas. I know it's a holiday, so happy holidays to everybody.
Yeah, thanks. And we'll see everybody in the new year. So thanks again for joining, and have a great weekend, everybody. All right, bye.